Good afternoon. Happy Wednesday. A couple of people, more than one, multiple people, have told me that I was wrong in my analysis of Jeff Gray's statements because various cases say that panhandling, soliciting for donations and things like that, is protected First Amendment activity. And I agree, it is protected First Amendment activity. But that's not where the analysis stops. That's never where the analysis stops. There's lots of things that are protected First Amendment activities that the government can and does restrict. For example, if you look at Adderley versus Florida, are protests protected First Amendment activity? Yes, they are. What happened in Adderley versus Florida? Well, all the protesters got trespassed from the curtilage of the jail in Florida. What do we learn from that? Do we learn that protesting is no longer protected First Amendment activity? No, we don't. We learn that there is a non-public forum analysis. So in a situation where a government building is being operated for a purpose, i.e. it's not a traditional public forum, then the government can limit expressive activity in that area. So all the government has to have is a legitimate government purpose for the restriction. And it has to be reasonably, the restriction has to be reasonably related or rationally related to achieving that legitimate government interest. And it has to be viewpoint neutral, which, I mean, that's okay. It's hard to do. Viewpoint neutral, if we take abortion, if I say no one can protest about abortion, that's content. So we're talking about the content. If I say no one can protest for abortion, well, that's viewpoint. If I say you can protest against abortion but not for abortion, that's a viewpoint-based restriction. So the non-public forum test to see whether or not the government can restrict protected First Amendment activity is, does the government have a legitimate purpose in making the restriction? Is the restriction rationally related to achieving that government purpose? And is it viewpoint neutral? That's it. Once the government meets those tests, excuse me, let me back that one up. If the person who's challenging that restriction on protected First Amendment activity cannot prove that the restriction is not rationally related to achieving a legitimate government purpose or viewpoint neutral, if the challenger cannot prove that, and the burden's on the challenger, then it's legitimate. It's a legitimate restriction on a protected First Amendment activity. So telling me it's protected First Amendment activity does nothing. Jeff Gray saying this is a protected First Amendment activity, yes. Jeff Gray saying, and therefore you can't restrict it or you can't criminalize it, no. Because again, we have to look at what the specific language of the restriction is. Is it a restriction specifically on city property, on like non-public forum city property, on City Hall? Is it a restriction just for there? If it is, we're probably going to use the non-public forum test. Is it a legitimate government interest? Is it rationally related to achieving that legitimate government interest? And is it viewpoint neutral? Now you're going to say, well, it's actually a limited public forum, John. Well, probably, but that limited public forum has to do with things where the government actually opens it up for that First Amendment protected activity. Like, for example, City Hall town council meetings, city council meetings, where they open it up for comment. That's the kind of speech. Or maybe they have a bulletin board in there where they allow people to post things. That would be the kind of speech that you would have a different analysis on. But if they're not allowing a specific kind of speech in there, then you revert back to the rational basis review. The legitimate government interest is the restriction rationally related to achieving that legitimate government interest, and is it viewpoint neutral? Now, there could be a completely different restriction. There could be a restriction that is a time, place, or manner restriction. I don't know that there is. I haven't seen any evidence that there is, but there could be. A reasonable time, place, or manner restriction drops the burden of proof from strict scrutiny, which it would be otherwise, because you're restricting speech in a public forum. It'll drop it down to a lesser form of scrutiny that the government, and now the burden shifts to the government. The government will have to prove that the government has a significant government interest. They have to prove that it's not content-based, and that it is a narrowly tailored restriction that is a reasonable time, place, or manner restriction. And maybe they're going to have to provide ample alternative channels for communication, depending on what it is. That means, like, if they have a protest zone, the protest zone hasn't been moved so far away that the protesters can no longer communicate with their target audience, although I've seen where that's happened, so your mileage may vary, but generally that's the gist of it. So you've seen it, we saw that in Ward versus Rock Against Racism. The significant government interest was that the people in the neighborhoods around the park, I think it was in New York, Central Park, the people who lived around that, they needed to sleep. They needed to be able to sleep. And so they had the Rock Against Racism had to keep the decibel levels of their music down to a certain point. It was a content neutral restriction. It was a manner restriction. And so the government had the significant interest. It was narrowly tailored to achieve that significant interest. I mean, it wasn't overly broad. It said you got to keep it down below this certain point. That's it. And it was content neutral, and it was a reasonable manner restriction. So again, the Rock Against Racism absolutely is protected speech, but the government could restrict it. They could restrict it. We've been through this multiple times with filming the police. Is taking pictures a First Amendment protected activity? Probably yes. There's I think it's the District of Columbia that has this weird rule that I have no idea why they did it, where if you're live streaming, it's protected, but if you're just recording it to play it later, it's not. I don't get it. I don't think that's going to survive long. Maybe it will. Maybe every other circuit's going to get overturned, and they're going to go with the District of Columbia version. Maybe, but be that as it may, we've been through this with filming the police. It is, or with filming in public in general. It's subject to various restrictions. When you walk into a government agency like the Social Security Administration, all of a sudden any rule on filming has a lower scrutiny that it has to survive in order for it to be a legitimate restriction on your First Amendment protected activity of filming. That restriction, it gets harder and harder the closer you are to a traditional public forum. And the further away you are from a reasonable time, place, or manner restriction. That's why in Turnervy Drive or in all these other cases, they all talk about, you have a First Amendment right to film the police, subject to reasonable time, place, and manner restrictions. They all talk about that. I mean, the First Circuit has a little bit different opinion on how it plays out, and I think another circuit does too. Other circuits are talking this is just a traditional public forum test, reasonable time, place, and manner, traditional public forum kind of test. But be that as it may, all of these things are talking about restricting protected speech, restricting First Amendment protected speech. Now, remember, there is some kinds of speech that is not protected. True threats, not protected under the First Amendment. Fighting words, not protected under the First Amendment. We don't even have to do the analysis. I mean, the government just gets to restrict those. Panhandling is protected First Amendment speech, but that doesn't mean the government can't restrict it. It means that the scrutiny it has to pass, the scrutiny it has to survive in order to restrict it is a little bit, there's some there. There is some there. But how much it has to survive depends on where you are and what the ordinance is. No, it depends on what the ordinance says. It depends on what the ordinance says, or the law or statute or policy says. Anyway, I hope that's enlightening. So Jeff Gray is right that it's protected First Amendment speech. He's right, but he is wrong in that it can be restricted. And again, I point you to Coquinda. Coquinda, they were soliciting donations and they were handing out political flyers. The post office can restrict that speech. The post office said, no, you can't be here. Even though the post office allowed other kinds of speech on there. There were kids selling Girl Scout cookies and other things. That was fine. But the post office could say no none of these political solicitations, no soliciting for political contributions and things like that. In Lee versus International Society for Krishna Consciousness, again, protected speech, panhandling. It's part of their religion that they ask for and accept donations. That's literally part of the Hare Krishna religion. That can be restricted in airports. That's Lee versus the International Society for Krishna Consciousness. It is protected First Amendment speech, but it can be restricted, i.e. by a law, rule, regulation, ordinance, policy, etc. And those can have fines or jail time or other things associated with them. You can get trespassed over them, blah, blah, blah. So Jeff said that there was a U.S. Supreme Court case that applied. There is not. I cannot find one. If he has one, I would love to see it. Jeff said there's a Florida State Supreme Court case that applied that said that prohibitions against panhandling are all void. They are all repugnant to the Constitution. I would love to see that case. I really would. I don't believe it exists because I couldn't find it. Now, if he has it, I would love to see it. And again, I'll throw myself on my sword and say I was wrong, mea culpa. But just posting in my comments that it is First Amendment protected activity. I mean, yes, and it's the part about where the government can't restrict it at all. Period. That's the problem, because there are tests that we apply to restrictions on protected speech, and all the government has to do is survive one of those tests, and all of a sudden, bingo, bango, bongo. Love you in the Congo. Have a great day.